I now call the first case on the docket. That is case number 110656, Byron Weishman v. Mark Huddleston.
May it please the court, Stanford Smith Jr. appearing on behalf of the appellant Mark Huddleston. Counsel, this matter comes before the court on the appellant Mark Huddleston's petition for judicial review. There are two jurisdictional issues before the court today. The first is whether or not the Court of Appeals and this court have jurisdiction to even hear this appeal. And second of all, whether the district court acted outside and without jurisdictional authority when it set aside a judgment dismissing the tort case against my client 4.5 years after the dismissal. And I would be remiss to say I should have asked for 5 minutes rebuttal.
5 minutes is granted, counsel.
The district court setting aside of the judgment of dismissal is limited by KSA 60-260. In reinstating the case 4.5 years after it had been dismissed, the district court cited no statutory authority and simply found it was fundamentally unfair to allow the dismissal to stand. The district court had no such authority or jurisdiction under KSA 60-260. Therefore, an immediate appeal was taken under the jurisdictional exception pursuant to Brown versus Triple D in the cases cited therein. And this leads us to the first jurisdictional question before this court, and that is this court's jurisdiction to hear the appeal and the Court of Appeals' jurisdiction to have heard the appeal. The Court of Appeals found it did not have jurisdiction to hear the appeal, basically overturning this court's decision in Brown versus Triple D. The Court of Appeals erroneously reasoned that the Park City case, which abrogated the exceptional circumstances equitable doctrine, somehow also abrogated the jurisdictional exception. Might note that the Park City...
Counselor?
Yes.
Somehow was Park City said there is no equitable exceptions.
That's correct. And the jurisdictional...
And so why isn't this an equitable exception to jurisdictional statutes?
It's not an equitable exception. It's a judicially recognized legal exception where the court acts extrajudicially without jurisdictional authority.
Well, let's dial back one extra step here. We can all agree that 60-2102, which is the statute that sets out the right of appeal, that statute has no application to your particular appeal. You don't qualify under that statute.
No question. This is appeal from a non-final order, and we are not appealing under the interlocutory statute.
And so when we have a lot of case law, Park City isn't an outlier. We have a lot of case law that says that this court's appellate jurisdiction is defined by statute. And so if we adhere to that and the statute doesn't apply, how can we hear this case?
Because where a court acts, a district court acts without jurisdiction, particularly in a situation here where it's reinstating a case without jurisdiction, Brown versus Triple D recognized and did so in many different circumstances. It found in Triple D it was the same situation we have here, where they tried to reinstate a case without jurisdiction. The court in Brown versus Triple D said, then you have a right to appeal on that jurisdictional grounds.
But Brown is still a judicially created exception.
Correct. And I would say it's illegal.
To the statute. And so was Park City. So from that stance, so I realize there's a difference between the unique circumstances exception and the jurisdictional exception, but just at base level, both are judicially created exceptions to the appellate jurisdiction statute.
Both are judicially created exceptions. One is an equitable one, expanding beyond the statutory authority a court's ability to grant an appeal even though the statute says you don't have an authority. And one is where the legal remedy, where the court acts without authority and without jurisdiction in contravention of the statutory authority. The problem here is the Court of Appeals said they're analogous. They're not, okay? The state ignores that the exceptional circumstances, the Court of Appeals ignored that the exceptional circumstances exception was an equitable remedy to attempt to enlarge appellate jurisdiction beyond what the statute authorized and gave jurisdiction to. Statute says you have to do it by this time. Park City, the court didn't have authority to grant the extension it granted. They said, well, we're going to take pity upon the poor lawyer who relied upon the court and allow it to go forward. Park City said you can't do that. The time limit is jurisdictional. Just as in the same thing with the statute of limitations, where you have the issue of commencement of an action, you can file it before 2 years, and then if you get service within 90 days, it will relate back. You can also get a 30-day extension if you request that extension for good cause within that 90 days. If you wait 91 days, the court has lost jurisdiction and the court cannot grant that additional 30 days. Okay? The courts have been clear on that. You can't move that way. The jurisdictional exception is different. It's a legal remedy where the court acts without authority, without jurisdiction, in contravention of the statutory authority.
So is our case law that says appellate jurisdiction is defined by statute, is that case law wrong?
It is wrong to the extent it doesn't recognize that the jurisdictional exception is still valid, not only in Brown versus Triple D, but in numerous federal court cases under similar statutes that have said that court acting without authority or jurisdiction is subject to immediate appeal and review. And it makes sense. It makes sense. Let me go back to the example I gave on the statute of limitations. The court grants the extension 92 days after the 90 days, or 2 days after the 90 days is run. The defendant gets served. The plaintiff or the defendant moves for judgment as a matter of law because the statute of limitations has run. The court says, no, 2 days, that's fundamentally unfair. I'm going to let you do that. So then what happens is the defendant is forced to go through a trial, go through the entire process, only to find out that the court didn't have jurisdiction to require that whole thing to go on. We end up here 3 and 4 years later after having tried the case when the court didn't have jurisdiction from the moment it entered that order. And there's no reason for judicial economy or any other reason to subject the defendant to that.
Excuse me, Counselor. Speaking of judicial economy, you did have a method. Let's go back. What we're talking about is an early appeal. Obviously, if you would have accepted the ruling, tried the case, then appealed, one of your issues could have been that the court erroneously set aside the dismissal. Correct?
Correct.
You had a pathway to come up here and have us decide that issue. You had a second pathway where you could do it early. Your judicial economy. You could have had it certified as an interlocutory question and moved for leave to file it in an interlocutory method. So why do we need to have a court-made rule to give you a third path to get to this court?
Two problems with the first one is the problem I just described. You have to go, a court acting without jurisdiction, you still have to go through the trial and everything else, and the court never had jurisdiction to begin with. The fact the court didn't have jurisdiction.
But if you go through that trial and win, it's over.
True.
You go through that trial and you win, you actually your client gets relief quicker.
Not necessarily.
Potentially quicker than filing an appeal with the Court of Appeals, petition for review to the Supreme Court. So if you're talking about judicial economy, that actually would have been more economical to win at trial.
I don't know that I agree with it more economical because of the cost of the trial.
Okay.
Maybe more timely, okay?
Yeah.
But I want to address the interlocutory argument as well. because you said, well, I can file under 2102 for an interlocutory appeal. That assumes that the court had jurisdiction to begin with. Why would I ask a court, whom I'm saying did not have jurisdiction to even reinstate the case, to issue another order? That's inconsistent with the jurisdictional exception, which says, Your Honor, you don't have jurisdiction to act in this case. Why would I then file something with that same court asking him to do something different? He didn't have jurisdiction in the first place. Why would he have jurisdiction to enter interlocutory relief?
That's
Second of
right.
all, why
So
should I be at the whim of that same court as to whether or not he's going to grant that relief?
Are you saying that the court didn't even have jurisdiction to hear the motion?
The court had no jurisdiction in this case 4.5 years after the case had been dismissed.
I
Yes.
understand the argument that the court did not have jurisdiction to grant the motion and proceed with trial, but I'm not sure I understand why the court wouldn't have had jurisdiction to even entertain the motion.
I don't know the answer to that question as far as entertaining the motion itself, but I do
Because there are
believe.
grounds for 6260 relief.
Correct. If one of those had applied. B1 and B3 require within 1 year. B6 requires within a reasonable period of time. This was 4.5 years after the dismissal, so I argue obviously that that wasn't a reasonable period of time.
But
So
so
the
you're-
court had a jurisdiction to entertain the motion.
Your jurisdictional argument is based upon merits.
And the courts have recognized under the jurisdictional exception that there is a mix between the merits of the issue on jurisdiction and the jurisdictional issue and the jurisdictional exception. So yeah, there has to be somewhat of a mix, because the court could entertain the motion, but the moment it granted the motion and reinstated the case, it didn't have jurisdiction to do so because 6260 under any of the provisions didn't give it authority to so act.
I'd like to kind of go back to just a real fundamental point
Certainly.
of where we really have to start in this analysis, and that's with Article 3, Section 3B, or 6B, I mean, of the Kansas Constitution. And the wording of that is that the district courts shall have such jurisdiction as in their respective districts as may be provided by law. What does law mean in that?
60-260 in that case.
And only 60-260?
In the context of setting aside a judgment, yes.
Why does not a decision of this court constitute as provided by law?
If I understood you right, it was talking, what you read to me was the district courts, not this court's jurisdiction. And my
Right.
point was 6260 controls the district court's authority to set aside a judgment. And once it did so without the authority of 6260, or contrary to the authority of 260, it was acting extra jurisdictionally.
Why cannot this court, through a judicial decision such as Triple D, grant authority and jurisdiction as provided by law?
I believe it can. And I believe Triple D does state that right there, that this court has the authority to consider an appeal on jurisdictional grounds under 6260, just like the court said in Brown versus Triple D, to determine whether or not the district court acted extra jurisdictionally. In this case, they did. It doesn't qualify under B1 and B3. He acted outside of the 1 year. Our argument is that both B1 and B3 have a 1 year limitation, and those were the applicable ones. But even under B6, the court didn't have authority to reinstate this case 4.5 years later.
You're losing me again.
Okay, sorry.
Because you're mixing now we're mixing the decision power of the court with the statute. And I'm asking, does this court have the ability, independent of the statute, to issue a decision that would grant a basis for jurisdiction in the district court?
If this court has the authority to determine whether or not 60-260, the provisions of 60-260 apply and therefore reinstate the case. If this court finds that the appellee, the plaintiff, met the conditions of 60-260. I think it would be error for this court to so rule. So are we on the same page there?
Not
I-
exactly.
Could I Could I try to help
Yeah.
out a little bit? Article 3 in Section 1 and Section 6B talks about jurisdiction, whether it's the Supreme Court or the district courts, quote, as provided by law, unquote. And this court has pretty much traditionally said that means it is the legislature's power to tell us what jurisdiction we have.
Correct.
You would agree with that?
I would agree with that.
And you are here today, as I understand it, asking us to preserve a judicially created exception, not a statutory or legislative exception to jurisdiction, but our own created exception to jurisdiction, which seems to be contrary to what Article 3 says. Is that your position?
My position is that Brown and Ranieri, which is a Second Circuit case, that Matee, Herbal, Landscape, Stradley, all those Kansas, well, Matee, Herbal, and Landscape are Kansas cases. Stradley is a Third Circuit cases, and all those cases that recognize the jurisdictional exception to the statutorily created appellate authority are good law and valid law and should be adhered to by this court. Yes, it is a judicially created exception where a court acts outside of it, where a district court acts outside its jurisdictional authority.
And how can we square that with Article 3 of the Constitution, which basically says the jurisdiction for the courts in Kansas comes from the legislature?
Because as the courts that I just cited in Kansas that recognize these exceptions said, you can't grant a new trial without jurisdiction, and if you do, you have a right to appeal it. And because this issue's been decided, I guess is my point. And unless you're going to overturn directly, and I argue that Parks does not directly overturn, or Park City does not directly overturn Brown versus Triple D, unless you're going to completely overturn Brown versus Triple D and all the cases cited therein, and unless you're going to differentiate the federal jurisdictions, which even after the U.S. Supreme Court decision in Bowles, which was relied upon by the Park City case, talking about the exceptional circumstances existing, said, no, the jurisdictional exception still applies. Matter of fact, the Court of Appeals in the In Re, the marriage of areas, after Park City said the jurisdictional exception survives and is still here.
The problem with that argument, citing to that Court of Appeals decision, is yes, it occurred after Park City, but they didn't even acknowledge Park City. They didn't mention it, did they?
They did not acknowledge. They
So,
did
I
not
mean-
mention Park City.
I mean,
Nor did the
I don't
plaintiff
think
in
we
this
can.
case.
I mean, I don't think we can imply. I don't think it's fair to imply, at least, that the marriage of areas case took a different analytical path than the Court of Appeals in your case, because they just simply didn't talk about Park City. They may not even have noticed it as they were doing their work. So I don't think that's quite fair to tag that case over to your side of the ledger.
Well, my point with it, and I agree with you, they did not specifically address Park City. Frankly, neither did the plaintiff in his briefs in this case, nor did the defendants in the briefs in this case. The first time Park City reared its head was in the decision. It didn't come up in oral argument, it didn't come up in argument, and I believe it is distinguishable regardless of whether In Re, the marriage of areas, discussed it or not. And that's what I'm here today to point out is Park City talks about an equitable remedy to basically say, yeah, you didn't follow the statutes, but we're going to let you appeal anyway. And in this case, we're saying the court acted contrary to the statutes. And in those situations, the only relief, or the best relief, because you're right, I mean, well, I don't think interlocutory applies because that's contrary to the court having jurisdiction. Going through the trial and everything else, yeah, that's an option. It shouldn't be an option that a defendant has to take when the court acts without jurisdiction.
Let's talk about a practical aspect.
Sure.
You're saying that this court, the appellate courts, have jurisdiction over an early appeal that hasn't used the interlocutory procedure, that there's no statutory procedure, if the district court had lacked jurisdiction.
Correct.
And so basically we have to decide the merits of your claim in order to determine if we have a jurisdictional exception?
You have to determine whether or not the court acted within or without the authority of KSA 60-260 in reinstating the case in order to determine, one, that you have jurisdiction, and then two, to reverse the district court. Correct.
Well, so you agree with that statement?
Correct.
Under that exception, we have to determine the merits to determine if we have jurisdiction over an early appeal.
I think it's a legal issue that the court can consider de novo, and yes, the court has to determine whether or not 60-260, any of the provisions of it, allow a district court to reinstate a case that has been dismissed for approximately 4.5 years. Yes.
Do we have any further questions? Thank you, counsel.
Thank you.
Counsel, as you begin your argument, I neglected to ask opposing counsel to give our audience a little factual background as to what brought us here. This so far has been kind of a dry academic argument, but this is a car accident, correct?
Yes, may it please the court. It did arise out of a car accident. There was a settlement agreement after the accident, after the action had been filed. The insurance companies didn't honor the settlement agreement. But before we learned they weren't going to honor the settlement agreement, my client's attorney notified the district court that the case had been settled. So the district court in due course dismissed the action. The settlement agreement was for $25,000. My client didn't get paid by the insurance companies. So he filed a breach of settlement agreement lawsuit, a second lawsuit. At the same time, he filed a motion to set aside the dismissal, which is why we're here today. District court granted that motion. Frankly, my client didn't have any interest in this case anymore. We've received judgment on the settlement agreement in the full amount of the $25,000.
Well,
In your
just-
separate lawsuit.
In the second lawsuit that was filed after they didn't honor their promise to pay the $25,000 amount.
And I want to talk about the honor, the promise. The insurance company went ahead and were willing to pay $25,000.
They were not.
Except they wanted to pay $7,000 of that to the personal injury protection carrier that had paid your client $7,000. So they were going to reimburse your client's insurance carrier for part of that. And the argument was, usually what the argument is, I assume, was whether they were duplicative, whether those payments, whether the payments from your insurance company to your client duplicated the claim that your client was making against the other party. And that is a fairly common fight, isn't it? In these circumstances, whether your client, whether the injured person gets all the money or whether they only get the amount of money that their insurance company hasn't paid. Isn't that a common fight?
I don't know. Let me tweak that factual recitation just a little bit, though.
Okay.
And that is, they didn't want to pay $7,000. They had already paid $7,000. And then when they entered into the settlement agreement, they said, we will pay Byron Weishman $25,000. And there was no provision saying less the $7,000 we've already paid. There was nothing in there to suggest that the $25,000 was exclusive of the $7,000. They actually only wanted to pay us $17,000, and that was not acceptable. We, some time ago, won a summary judgment motion, received judgment for the $25,000, full $25,000 amount. What we didn't get is interest, and there's another ruling that we went ahead and appealed. That's pending for the Kansas Court of Appeals. The insurance companies cross-appealed originally the judgment for the $25,000. They recently filed their brief and abandoned any appeal of the judgment in favor of Byron Weishman and against the insurance companies. So that has recently become final. Mr. Weishman is not entitled to two judgments. He can't both get a judgment on the settlement agreement and get a judgment on his personal injury action. So in due course, when this case finds its way back to the district court, his action will have to be dismissed. Consequently, so far as my client's concerned, this is academic. There's no case in controversy that affects him. He's got no interest in this. It's interesting. All the questions from the justices show you just how interesting the academic legal question is as to whether or not the Court of Appeals interpretation and extrapolation of Park City is accurate. But other than that, I don't have anything to address.
When did your claim for the breach, the second lawsuit, get resolved?
It became final when they abandoned.
And when did that happen?
What was it, 3 months ago maybe? We filed a motion, or actually it wasn't a motion, it was a notice to waive oral argument given the circumstances. Somebody interpreted that as a motion to waive oral argument and denied it. So we came see if there's any questions of the court that we can address, but he simply doesn't have any interest in this.
Is this I guess my question is this the first time we're getting notice of the second lawsuit and basically the resolution of this case? Have you been paid?
No, they did not pay us.
Subject to the question of the interest, or what's it?
I don't know why they haven't paid us, other than when they cross appeal.
Are you going to wait another 4 years and then try to figure it out?
Well, we can't execute on it, or we'd acquiesce in the judgments part of the judgment that we've appealed. Originally, I understood they couldn't pay the judgment because they had cross appealed. Now that they've dropped their cross appeal, there's no reason why they couldn't pay it, but they haven't paid us.
Is there any relief that anyone can get out of this appeal?
Yeah, what's going on?
If Mr. Huddleston wins and it goes back and say we rule that the district court was incorrect to set aside the dismissal and that it should have been dismissed, why doesn't that give Mr. Huddleston some relief?
He'll get the same relief if the court agrees with the Court of Appeals. The case will be dismissed.
That's what you said, isn't it?
Well, the Court of Appeals said that the district court had jurisdiction. There was no appellate jurisdiction. So he'd go back, and instead of honoring the stay order that was entered after the court set aside the judgment, you recall there's a stay order involved. Talk about judicial economy. Judge Leahy entered a stay order staying the case. Mr. Hudson decided not to honor that, and he filed his, instead of seeking relief from the state order, filed an appeal. He just filed the appeal. But in terms of your judicial economy question, that was provided for by Judge Leahy by staying the case pending the resolution of the breach of settlement agreement case. Because if we win the breach of settlement agreement case, the personal injury case goes away. That's exactly what happened. So what we have,
are we here being asked to issue an advisory opinion that does not affect you or your client, but affects perhaps future litigants? Is that your position?
I think it is. I think it is an advisory opinion. I don't think there's a case in controversy here. I'm not here to argue that the Court of Appeals was correct in their extrapolation of Park City. My client just didn't have any interest in that.
See, I don't understand that, because I'm looking at your waiver of oral argument document, which as far as I know is the only other document besides the briefs, and you ask us to affirm the Court of Appeals decision. You don't tell us anything about having won the other case. So this is the first we've heard that there isn't a dog fighting anymore, or two dogs fighting in this case. So that's, that really is kind of a stunning thing to be coming here and saying when you haven't told us that you've resolved it, and you asked us in your document that was just filed earlier this month, or earlier in February, that you want us to affirm the Court of Appeals.
Yeah, if I'd known that the waiver wasn't going to be honored, I'd did a better job of explaining why my client was interested in waiving oral argument.
Well, it goes beyond oral argument. It's a question of whether we even can issue a decision if the issue is moot.
And I don't know the question that, there is a jurisdictional factor in here, and the court may decide that whether it's an advisory or not, This goes to subject matter jurisdiction of appellate courts, which the court always has an interest in raising, even on its own volition. And I just don't know how that, the competing principles, advisory opinions, and case and controversies and subject matter jurisdiction interplay in a case like this.
Help me understand exactly what the status is of this other case. Has the Court of Appeals issued an order of dismissal or any kind of order post briefs?
On the breach of settlement agreement
breach of
case,
settlement agreement case?
that's pending for oral argument 2 weeks in Wichita.
Okay, so when you say that the insurance company has essentially acquiesced on the judgment, there still remains some other issue in that case?
They acquiesced on the judgment entered in the principal amount of $25,000. The only issues now that remain are the issues that we raised in our appeal, whether or not prejudgment interest should be awarded, number one, and number two, whether a motion to amend to assert a fraud claim against the insurance company should have been granted. Those are the only two issues that remain, given that their brief did not address the issues they raised in their cross appeal. They say in their brief they've abandoned those.
Well, in the event that we decide that we still have a reason to decide this case, let me put you over to the merits real quickly. I'm having a hard time understanding what the district court did in granting your motion to reactivate the case, because it does not, would you agree with me that it does not appear that the district court actually followed the statute, KSA 6260, in its analytical path to granting your motion?
No, I probably would not agree with that.
You wouldn't agree with,
No.
Do you think the court did follow the analytical path?
Yeah, I think he granted it based upon B6.
But, so walk me through the analysis that the court did. Because here's my point. I think what the district court did was say this was an administrative dismissal and I can do anything I want because it's an administrative dismissal, because I asked Judge Fleetwood and he said I could do anything I want, and so I'm going to do what I want, as opposed to going through the elements of 6260 and saying these elements apply and therefore you are entitled to relief. Do you see the difference that I'm making?
I guess if the question is, did he expressly say it's being granted pursuant to the statute that the motion was made under? Frankly, my recollection just isn't good enough to recall whether he said that. But even given that he did not say that, it's clear the motion was based on B6, and having not filed...
What makes that clear?
The oral argument in support of the motion, when the attorney, it wasn't myself, it was another attorney, pointed out that it should be granted pursuant to, I think he referenced two sections and B6 was one of them. Now keep in mind, they didn't file a motion for specific findings after the motion was granted. So I think the standard appellate principle would apply, which is that the court is presumed to have found the facts necessary to grant the motion under that provision. There's a legion of federal case law that says when you've got a settlement agreement and the case is dismissed and the insurance company doesn't honor the settlement agreement, that's a B6, a motion to set aside the judgment. There's no question about it. They didn't cite any case law to the contrary. I didn't find any case law to the contrary. So the court, you may be correct in his thought process, but I think there's some appellate principles that bail us out.
Well, I don't know about the thought process. I only know what's in the transcript. And what I don't see in the transcript is a recitation of the factual findings that you would normally expect under 6260 to grant relief to the party filing the motion. And what I do see is the judge saying, well, this is an administrative dismissal. I can do anything I want. So I choose to do this.
He may have been talking about how the the original dismissal was granted by one judge, and it wasn't necessary that the motion to set aside the dismissal go back to that same judge. You may have been talking about that. I'm not clear.
Counsel,
Yes.
I just have one question, if I can back you up to what we were talking about a moment ago on what is pending before the Court of
Yes.
Appeals. I think you said you're due for oral argument in 2 weeks.
Correct.
You mentioned that the interest issue is still in dispute. And then I think you said something about a motion to amend to add a fraud claim?
Yes.
So that is outside whatever's now been settled and abandoned?
It's a fraud claim against the insurance companies.
Okay,
It
Okay.
doesn't involve Mr. Huddleston.
okay, got it. Thank
You know, Mr. Huddleston, his own motion for summary judgment in the breach of contract case was also granted, and that's not a subject for appeal.
Okay.
He's done pretty well, and I don't know how he gets any, improves his position with, you know, this petition for review. Granted, you know, his position changed mightily after the petition for review was filed, and it changed after it was granted. But he's in the catbird seat. You know, he's got no risk at this point that I can tell.
Just so I'm clear, to use a vernacular, it's your position, Mr. Huddleston has no dog in the fight either? Is that what you're saying?
Yes, I think it's academic as to him as well. Having won his motion for summary judgment, he's not liable on the settlement agreement, and there being no issue on appeal on that settlement agreement, I don't know what his jeopardy is.
We have any further questions? You have 26 seconds left. Any further presentation?
Thank you.
All right, thank you, counsel. You reserve 5 minutes for rebuttal.
Thank you. As far as Mr. Huddleston is concerned, this case is still pending against him. Plaintiffs haven't taken any action to dismiss this case or to act in any other way. And right now, because of the Court of Appeals decision that says there's jurisdiction to proceed in this case, there's still a case pending against Mark Huddleston. You know, we have a dog in the fight. You know, what Mr. Beal's saying, I'm not involved in that other Court of Appeals case. I don't know what the status of that is, other than it is on my calendar for argument. And I told my secretary yesterday, I don't need to appear at that one, because I'm not involved in that case.
So it'd be your position that opposing counsel could just file a dismissal in this case at the district court? And your dog would be out of the fight?
If this case is no longer pending, either because there is no jurisdiction or because they've dismissed the case, then I think I'm done. I mean, yeah, you're right. I would hate to frankly see the Court of Appeals decision stand, which abrogates the jurisdictional exception under Park City, because I don't think Park City is applicable to the jurisdictional exception. And so I do believe that the issues of subject matter jurisdiction are important to this court and should be addressed by this court. But frankly, this idea that it's somehow moot or whatever I'm hearing it for the first time today too. I mean, he's never called me and said, hey, how about we just dismiss the case? As far as my client's concerned, there is a case pending against him, subject to this court's ruling as to whether or not the district court had jurisdiction to reinstate the case.
Mr. Smith, can you tell me what risk is out there for your client right now today in light of the breach of settlement agreement case? What risk in this case is there? I don't know
if this court sustains the Court of Appeals, this case goes back to the district court for trial against my client.
But what's the practical risk to your client at that point?
They can, as far as I'm concerned, they can proceed.
Despite the findings in the breach of settlement agreement? Despite the settlement agreement, you think they
The
can
tort
proceed?
case would be reinstituted.
Okay. So that's your client's position, is that he's still at risk?
It would be reinstituted, and whether or not he would be subject to potential liability over and above the $25,000 because he is a defendant in the case or not, I don't know. I mean, I'm certainly sure they'd like to take that position, that just because the settlement was entered into or granted, the breach of settlement was granted against him, he could have some excess exposure. I don't really know the answer to that question, because this is the first I've heard that they're taking the position that they're not going to proceed on the tort case. I mean, as of the day he filed his waiver of oral argument the other day, he asked this court to affirm the Court of Appeals, and also, if they are going to reverse the Court of Appeals, to remand it to the Court of Appeals to consider other arguments he made before them to establish jurisdiction.
So if opposing counsel were to stand up right now and say, I shall dismiss the case, you would dismiss this appeal and you would all go home?
No.
All right.
I would agree that my client would have no exposure, and I would still ask this court to rule on the subject matter jurisdiction issue as to whether or not Park City overruled the jurisdictional exception, because I think that's an important judicial issue, and that the Court of Appeals decision, which appears to do away with, well, it does, says the jurisdictional exception is no longer valid, is improper.
And if we
Now,
had,
if this court wants to decide that's a advisory opinion, that's your prerogative. I can't tell you that that is.
very well.
A couple of things, just real quickly. Plaintiff knew the issue regarding the settlement before the dismissal was entered. The issue about whether the PIP lien and how that was going to come up, that the record's clear. The plaintiff's counsel knew that prior to the case actually being dismissed. After the notice of dismissal, before the dismissal actually took place, he took no action to stop the dismissal. He waited 4.5 years to reinstate the dismissal, and there was no reason given for the delay. Therefore, I don't believe 60-260 under any provision gave the district court jurisdiction to reinstate this case against my client. And I do believe the jurisdictional exception is a valid exception and has been found to be valid in cases here and in federal court. And as far as the federal court cases Mr. Deal cited or said there's plethora of, that if a settlement falls apart you can reinstate the case, we address those in our briefs and distinguished each and every one of those cases. If there are any other questions, I'm concluded.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.